So good morning to those of you that have just joined us. We have just opened the link, so we will wait for a few minutes just to allow everybody to join us. So for those of you that have just joined us, we're just waiting for a few minutes to allow everybody to join onto the link before we start. For those of you that have just joined us, we're just waiting for a few moments for everybody to join the link. Just so you're aware, we are using the Zoom webinar program, which means that you will not be able to see hundreds of little boxes of people appearing in front of you. You won't see any other participants, and they don't see any of your details either for GDPR purposes. We're just going to wait for a few more minutes just to allow everybody to join this link before we start. Good morning, everybody, and welcome to the Five Stone Buildings webinar program. Today we will be hearing from Edward Hugh, and I'll hand over to him.
Thank you very much, Jo. A very warm, if somewhat virtual, welcome to all of you to this Five Stone Buildings webinar, Are Success Fees Recoverable in 1975 Act Claims. As Jo has mentioned, I'm just going to address a few points, a few housekeeping points before we begin. We are using Zoom for webinars, which means that you don't, I'm afraid, get to see lots of little pictures of your colleagues and competitors, studies, living rooms, and possibly even bedrooms. I'm afraid you're just stuck with me and my slides. What you do have is a Q&A function, a little button on your screen in which you can type in questions that you would like me to address please do so as we go along, and I will then try to address some of those questions at the end, time permitting. The webinar is being recorded, so please feel free to tick the anonymous box if you would like to ask questions anonymously, and I won't mention any names. And also, of course, please feel free to then access the recording, which will be available on our website, 5sblaw.com, after the webinar has been uploaded. So that's the housekeeping. Let's move on to the subject matter of this webinar. So, as I say, are success fees recoverable in 1975 Act claims? Now, for those who are familiar with the Jackson and legal aid reforms brought in by LASPO in 2012, and indeed with a case called Clarke and Allen, which was decided last May, you may well be thinking this could be a very short webinar. And indeed, I think, had I been asked to deliver it about 2 months ago, I would have not been able to say much more than, no, they are not recoverable, and Clarke and Allen is High Court authority for that proposition. End of webinar. Now, you may or may not be pleased to hear that there is a bit more to that now, as a result of 2 recent cases called Bullock and Denton, decided on the 15th of April of this year, and Re-H, which followed a few weeks later on the 7th of May. Quite what the answer to the question posed in the seminar actually is, I think is probably a matter for debate, as we will see. I suspect the best formulation I can come up with at the moment on the state of the authorities is sometimes some of it, but I'll come on to explaining to you why we get to that. What I'm going to do is start off briefly. I'll try and keep this brief. There's quite a lot to be said, but I'll try and keep it as brief as I can, with a sort of canter through the Jackson reforms and the legal aid reforms which led to LASPO. And the reason for that is because I think it's quite a useful way of putting into context the problem that we are dealing with when considering uplifts in 1975 Act claims and how that problem has come about. I will then look at the 3 cases I've just mentioned, Clarke first and then Bullock and Re-H. I'll focus really only on what the judges had to say about recoverability of CFA uplifts or success fees in each of those cases. I'll then give you my views about what I think are some difficulties that the last 2 cases throw up, in particular Re-H, which I'll be looking at in a little bit more little bit of detail. And then I will finish off by considering some of the practical implications that I think flow from these cases for those of us who deal with 1975 Act claims, both for claimants and for defendants on a day-to-day basis. So let's start with Jackson. The Jackson reforms were the basis on which the removal of recoverability of uplifts in CFAs came about. The way that the removal was brought in was by an amendment to Section 58A(6) of the Courts and Legal Services Act 1990. That subsection was amended by LASPO to read as follows: a costs order made in proceedings may not include provision requiring the payment by one party of all or part of a success fee payable by another party under a conditional fee agreement. And so that's quite clear statutory wording as to recoverability under a costs order of a success fee or uplift. And that applies from 2013, now effectively across civil litigation. There were some exceptions which are not relevant for present purposes, but for our purposes, that applies in civil litigation generally. And the reasons which led to that reform were really the work carried out by Sir Rupert Jackson in both his preliminary report in 2008 and then his final report in December 2009. A huge amount of work clearly went into those reports. They cover all sorts of other topics as well, but I think that the final report itself is over 500 pages long, and I think the preliminary report is divided into 2 parts, equally, each of which is several hundred pages long. But I think it's quite interesting to look at what I might call the executive summary of the final Jackson report, published in December 2009, and what Sir Rupert had to say there about CFAs. And it begins with paragraph 2.1, so it's very much at the forefront of these reforms is CFAs. And he says CFAs have been a major contributor to disproportionate costs in civil litigation in England and Wales. There are two key drivers of costs under such agreements, being one, the lawyer success fee, so the uplift, and two, ATE after the event insurance premium that is usually taken out when a CFA is entered into. Both the success fee and the ATE insurance premium are presently recoverable from an unsuccessful defendant. And in the next paragraph, he says, I recommend that success fees and ATE insurance premiums should cease to be recoverable from unsuccessful opponents in civil litigation. If this recommendation is implemented, it will lead to significant cost savings while still enabling those who need access to justice to obtain it. It will be open to clients to enter into no-win, no-fee or similar agreements with their lawyers, but any success fee will be borne by the client, not the opponent, as we know, as anyone who nowadays deals with CFAs in 1975 Act claims well knows. Now, what's quite interesting, it seems to me, about this is that in the following paragraph, immediately following that, Sir Rupert goes on to talk about consequences for personal injuries litigation. And it's quite clear, in my view, that a lot of the work that had gone into the preparation for the proposal for this reform was based on personal injury claims, where, of course, CFAs were very much common before 2009. And in relation to personal injuries litigation, Sir Rupert said that the importance of ensuring that successful claimants are properly compensated for their injuries or losses was rightly emphasised to me during the cost review. Indeed, it must be acknowledged that one of the benefits of the current CFA regime is that it is geared towards ensuring that claimants receive proper compensation. This, however, comes at a heavy price for defendants, who often have to bear a disproportionate cost burden. If the current regime is reformed along the lines I have proposed, so that success fees are no longer recoverable from an opponent in litigation, lawyers will still be able to agree CFAs with their clients, but any success fee will be payable by the client. This is likely to mean that the success fee comes out of the damages awarded to the client. And you can see the clear parallels with the problems we currently face in the 1975 Act claim context. What Sir Rupert goes on to say is, in the immediately following paragraph, increase in general damages. In order to ensure that claimants are properly compensated for personal injuries and that damages awarded to them, which may be intended to cover future medical care, are not substantially eaten into by legal fees, I recommend as a complementary measure to that, that awards of damages for pain, suffering and loss of amenity be increased by 10%, and that the maximum amount of damages that lawyers may deduct for success fees be capped at 25% of damages, excluding any damages referable to future care or future losses. In the majority of cases, this should leave successful claimants no worse off than they are under the current regime, whilst at the same time ensuring that unsuccessful defendants only pay normal and proportionate legal costs to successful claimants. It will also ensure that claimants have an interest in the costs being incurred on their behalf. So you can see that there are clear policy tensions in the context of personal injury claims, which is what it seems to me the Jackson reforms are primarily geared towards, and that there is an attempt to redress the problem which will be caused by removing the recoverability of CFA uplifts from the unsuccessful party by increasing damages for personal injury. And of course, the problems one can also see in 1975 Act claims, but we don't have that parallel solution that is proposed in relation to 1975 Act claims. There's also, interestingly, a comment on legal aid made by Sir Rupert Jackson, although legal aid was not strictly speaking something he was looking at. And he was very much, clearly, very much in favour of legal aid being kept as it then was in 2009, because he says, I do not make any recommendation in this chapter for the expansion or restoration of legal aid. I do, however, stress the vital necessity of making no further cutbacks in legal aid availability or eligibility. The legal aid system plays a crucial role in promoting access to justice at proportionate costs in key areas. And this link between CFA uplift recoverability and legal aid is a link that the then Chief Chancery Master Weingarten, had also made in one of his comments on Jackson's preliminary report, which is recorded in the final report, where he had said, my strong view is that success fees and ATE premiums visited on the losing side are quite simply an iniquity in a civilized society. It is in principle wrong for the paying party to replace legal aid. So there was quite a lot of favour, I think, in removing recoverability of uplifts from the unsuccessful party at the time of the Jackson reforms. But it seemed to me that that was very much premised on legal aid remaining available as it then was. And of course, we all know what happened to that. Just under a year later, in November 2010, the MOJ published its consultation on reforms for legal aid, which were clearly designed at cuts. The Chancery Bar Association was one of the, no doubt, many consultees who responded, and in particular it addressed both Talata and 1975 claims as areas where there were grave concerns expressed by the Chancery Bar Association that legal aid might be removed for 1975 Act claims. Despite all of that, a few months later, in June 2011, the MOJ published the government's response and said, we are going to remove legal aid, including, as you can see from the slide, in particular in relation to actions relating to contentious probate or land law, for example, actions to challenge the validity of a will, including 1975 Act claims, other than in the context of an in-scope family case. Both those reforms, so the removal of recoverability of CFA uplifts and the removal of legal aid from 75 Act claims, among other claims, came into force in 2013 as a result of LASPO. And I think that sets the scene, really, for the difficulty faced by the judges in the three cases I've mentioned, which I'm now going to turn to. The first of which was Clarke Allen. That was decided in May last year by Deputy Master Linwood, sitting in the Chancery Division. Very, very briefly, the facts were that in April 2010, the deceased had transferred his solely owned property into the joint names of himself and his two daughters. And then in July 2010, he had made a will leaving the property, his interest in the property, to his daughters and expressing the wish that his wife, it was his second wife, Matilda, would be able to live there for the rest of her life. And he left the residue of his estate, which was relatively minimal, to Matilda and his daughters equally. After his death, Matilda, the widow, brought two claims. The first claim was one to set aside the transfer of the property for mistake, and that was on the basis that there was evidence that the deceased had been advised incorrectly that, notwithstanding the transfer from his sole name into the joint names of himself and his two daughters, Matilda would continue to have a right to live in the property and it would not be open to the daughters to evict her, which was of course wrong as a matter of law. And the second claim by Matilda was a 1975 Act claim. Both claims succeeded. I won't deal with the facts in any more detail than that. And I'll focus instead on the costs. Matilda's solicitors and counsel were both acting on CFAs with 100% uplift, capped at 25% of the monies recovered, is the way it's described in the judgment. Base costs were said to be £192,000 at trial. And Matilda's counsel argued that LASPO did not prevent the court from taking into account Matilda's liability to pay uplifts under the CFAs with her solicitors and counsel as a financial need under Section 31A of the 1975 Act. And the reasons were summarised by the Master as follows. First of all, the requirement to consider financial needs of a claimant was unqualified under the 1975 Act. Secondly, Section 31A of the 1975 Act predated the current version of Section 58A6, which I've already referred to, by almost 40 years. Thirdly, that provision should not extend beyond costs orders because the wording was expressly confined to costs orders, and clear wording was necessary to impliedly amend the Act to apply more broadly. And the Deputy Master said, the submissions are ingenious, but I do not accept them. In my judgment, the responsibility for the success fee must remain with the party who entered into the CFA for these reasons. And he gave 5 the reasons, which I'll read out briefly. Calculation of damages is a matter of procedure carried out before costs are concerned. It has never included an element of or for costs. To permit the interpretation counsel suggests would be contrary to the deliberate policy of the legislature that the losing party should not be responsible for the success fee, that policy having been changed from that prior to January 2013, when such fees could be so claimed from the losing party. Thirdly, it would amount to an increase in damages by way of costs. Fourthly, it may put a CFA-funded litigant in a better position in terms of negotiations due to the risk of a substantial costs burden. Likewise, absent negotiations, it could lead to grossly disproportionate costs if a contested claim got to trial and the defending party lost. And I think that in particular is something that many of us who deal with 75 Act claims see on a day-to-day basis. Fifthly, there is no reason why a claimant seeking reasonable financial provision under the Act should be in a better position than one seeking, for example, damages for personal injury. So in May 2019, you have High Court authority for the proposition that the simple answer to the question, can success fees in 1975 Act claims be recovered, is no. Fast forward to April of this year, there was a decision of His Honour Judge Gosnell sitting in the Leeds County Court called Bullock and Denton. Very briefly again, the underlying facts were these: the claimant and the deceased had cohabited for 3 years and 4 months prior to the deceased's death in a property which was owned by him. There was some controversy about the nature and duration of that cohabitation, but that was the judge's finding. The deceased will left his £2 million estate to his brother. It was common ground that reasonable financial provision had not been made for the claimant. The claimant had initially instructed solicitors on a DBA, on a damages-based agreement, by which she had agreed to pay a third of her, again, quotes, damages, if that's the right terminology, up to £150,000 and 10% thereafter. She then changed lawyers and instructed a different firm of solicitors and a counsel on a CFA, both of which had a 50% uplift. The claimant again argued that her liabilities under the DBA and the CFAs were part of her financial needs, which she is likely to have in the foreseeable future. The estate argued that the Jackson reforms had made those additional liabilities irrecoverable, and that it would be wrong to award them as damages against the estate by the back door. Now, the judge noted that neither counsel produced any binding authority on this issue, perhaps because it has not been specifically considered before, which you may think is a slightly surprising comment and conclusion, given that there was Clarke, which, as I've mentioned, was decided in May last year. He went on to draw a distinction between effectively normal inter partes costs orders and the additional liabilities. And he said the additional liabilities fall in another category. And forgive me, this is a slightly long quote, but I think it's useful to look at the reasoning in a little bit of detail, particularly because we then have it followed in re-H. The judge said, I know that the claimant is going to succeed in her claim, perhaps not as extensively as she hoped, but this will trigger her obligation to pay additional liabilities to her lawyers. She will not recover them from the defendant as part of her costs, so they are a debt she has incurred since the death of the deceased and are part of her future financial needs. In my view, I am entitled to take them into account, both because they fall within the claimant's financial needs under Section 3(1)A, and because they are debts incurred since the death, and the court is enjoined to make the assessment under the Act at the date of trial, not at the date of death, Section 3(5) of the 75 Act. I am sympathetic to the defendant's argument that these are not costs that would in law be awarded against the defendant, but I think I have to look at the reality of the situation, or as Mr. Justice Briggs put it, in the real world. That's a reference to a very interesting cost decision of Mr. Justice Briggs, as he then was, in a case called Liamman and Liamman, which was also a 1975 Act claim, where a claim had been brought by a widow, and effectively Mr. Justice Briggs had been told to decide the case on the merits, ignoring the cost position, and he went on to make an award in favour of the widow, and then was told that the estate had made the widow a generous Part 36 offer early on in the litigation, which the widow had failed to beat. And so, of course, Part 36 consequences followed, and the widow had to pay most of her and the defendant's costs. And it's worth reading because Mr. Justice Briggs clearly highlights the practical problems that this causes, where a High Court judge has spent quite a lot of time and effort trying to make reasonable financial provision for this particular claimant, and is then told only a few weeks later, when one deals with costs, that in fact that provision, the claimant is going to have to pay on the facts of that case, a six-figure sum in relation to costs, which rather undermines the award. So that's Liamman, which is which all three of these cases refer to, and is worth considering as part of the background. The judge in Bullock went on to say, if I make no award under this head of claim, the claimant will have a substantial debt that she could only pay out of the other lump sum awards I have made. There may be very little left in the light of the fact that I have only awarded a life interest in her accommodation, which again is a very common problem in 1975 Act claims. When assessing what would amount to reasonable financial provision for her maintenance, I felt she was entitled to have her accommodation need met, and for her to be placed in a situation where she could manage afterwards an independent yet modest lifestyle. In order to be paid, this overall aim is placed in jeopardy, as it was in Liamman, which I just mentioned. The current issue is different to the one Mr. Justice Briggs wrestled with. In this case, I know for sure that the claimant will have these additional liabilities to pay. As I've said, in Liamman, it was a Part 36 offer, which of course the judge didn't know about at date of trial. This does not, however, mean that the defendants have to indemnify the claimant in relation to all her additional liabilities. In this case, the claimant took the unusual step of instructing a solicitor DBA. She then withdrew instructions and took on another solicitor and counsel on the basis of CFAs. By using two solicitors with conflicting funding arrangements, she may have committed herself to paying both uplifts, which are not in any way reduced by the other. She has therefore accidentally increased her liability for additional payments, and the defendant should not have to suffer because she has. There are issues about the enforceability of the DBA, and so I intend in fairness to leave that out of account. I'm not convinced I was ever given an up-to-date figure for the claimant's likely exposure to additional liabilities. On 7th of June 19, the figure stood at approximately 24,000 plus VAT. I anticipate that figure has increased substantially as a result of the trial. There is one aspect of this claim that is similar to the issue in Liamman. I do not know why the parties were unable to reach agreement in this case and chose to go to the very considerable expense of a trial. Judging from what I saw during the trial, the claimant's aspirations were unreasonably high and the defendant's position was both unrealistic and unreasonable. I believe it would be wrong in principle to make an award which effectively indemnifies the claimant. And the best I can do is select a figure for a lump sum award which makes a reasonable contribution towards a sum I know has been incurred by her. A figure of £25,000 on my assessment reflects such a contribution. So that's Bullock. A few weeks later, in fact about 3 weeks later, we have Re-H decided by Mr. Justice Cohen in the Family Division. You might have thought that Bullock, particularly in light of the comment by the judge that there was no binding authority, could be argued to have been decided per incuriam, given that there clearly was a previous High Court and therefore binding authority in the form of Clarke, and that it seems to me it's quite clear that Bullock is inconsistent with Clarke. However, in Re-H, we are back in the High Court in the Family Division, and we have a decision which does consider both Clarke and Bullock, as we will see. Very briefly again, the facts were that the claimant was the estranged adult 50-year-old daughter of the deceased, her father. She suffered from what the judge described as severe and debilitating mental illness. The deceased had appointed his son, the claimant's brother, as his executor and had left his estate to his widow. The claimant instructed solicitors and counsel on CFAs, both of which had a 72% uplift, and the uplifts were said to amount at date of trial to about £48,000 odd. As I've said, Mr. Justice Cohen referred to both Clarke and Bullock and decided to follow Bullock. And again, forgive me for reading out in some detail, but I think it's useful to look at the reasoning in quite a bit of detail. And I'll come back to this paragraph in a moment. I accept, he said, that it is appropriate for me to consider this liability, i.e. the liability to pay the uplifts, as part of the claimant's needs. I do so largely for case-specific reasons. I am not making a large award, unlike in Re Clarke. It is not an award that permits of much elasticity. If I do not make such an allowance, one or more of C's primary needs will not be met. The liability cannot be recovered as part of any costs award from the other parties. The liability is that of C alone. She had no other means of funding the litigation. And I'll come back to some of those points in a moment. I intend to adopt the same approach as His Honour Judge Gosnell in Bullock. I think that it would not be fair on C for me to ignore completely her liability to her solicitors, but I recognise that there is a risk of injustice to the estate, in particular if an appropriate Part 36 offer has been made, of which I am necessarily unaware at this stage of the proceedings. In addition, I flag up that I do not know the precise terms of the agreement and what is the definition of success. If my award does not bring about the operation of the uplift, I will revisit this element of the award. I cannot see, finally, how I can avoid some potential, and it is only potential, injustice to either C or the estate. All I can do is mitigate the potential by taking a cautious approach towards this liability. Bearing that approach in mind and knowing what I do of the case, I cannot envisage how it could reasonably be thought that the chance of failure was a high chance. I propose to allow the figure as part of the claimant's needs of £16,750, which approximates to a 25% uplift. Now, let me start by saying this. I think it is one can entirely see why judges have sympathy and have shown sympathy for both claimants in Bullock and in H. As I've said, in Liamman, Mr. Justice Briggs made comments to the same effect. The point is, if you have decided as a judge that you want to make this particular claimant an award so as to provide reasonable financial provision for him or her, it is then going to defeat that purpose or fly in the opposite direction of that purpose if you know or you are told that a significant part of the award you are going to make is going to end up paying lawyers' legal costs. So one can see the sympathy and where that judicial sympathy comes from. But it does seem to me that the reasoning, particularly in Re-H, is problematic, and that the current state of play of authorities does cause some real practical difficulties for practitioners, and I'll address each of those in turn. So first of all, going back to paragraph 55 of Re-H, you'll recall the judge said, I do so largely for case-specific reasons, and he gave these reasons. He said, I'm not making a large award, unlike in Clarke. Now, with the greatest respect, I'm not sure I see the relevance of that. Whether it's a large or a small award, I don't think as a matter of principle should make any difference. It is not an award, he said, that permits much elasticity. Again, perhaps slightly provocatively, one could say, well, none do. Indeed, if the award permitted too much elasticity, presumably the judge has done more than provide reasonable financial provision, than make reasonable financial provision for the claimant, and the award would be open to appeal. So the elasticity point, I'm not sure provides a helpful distinction or a helpful way of tying down the decision in Re-H to its particular facts. If I do not make some allowance, one or more of the primary needs will not be met. Well, again, it seems to me that is true in all cases. That's Liamman, that was clearly the case. And indeed, one can say in Clarke, that was the case. The liability cannot be recovered as part of any cost award from the other parties. Again, it seems to me that is true in all cases and doesn't really help tie the decision down to the particular facts of H. The liability is that of C alone. Again, seems to me that is true of all cases. The comment that the claimant had no other means of funding the litigation, well, that's quite interesting. It's not clear, and perhaps evidence and argument was produced to that effect, it's not clear from the face of the judgment whether attempts had been made or whether the judge considered that attempts should have been made by the claimant to find other means of funding the litigation. One that springs to mind, of course, is a Section 5 application under the 1975 Act for interim provisions, and I'm sure many of you are familiar with the case of Whites and Whites decided towards the end of last year, where the judge on an interim application awarded the claimant, it was admittedly a large estate, but he awarded the claimant, I think £55,000 from memory towards her legal costs up to and including an FDR by way of interim provision, so that the claimant had proper funding to pursue her claim. And I also ask rhetorically, does this sort of introduce a measure of means test? So is there an element of the court having to consider whether the claimant had other means of funding the litigation, and for example, deciding that if the claimant was able to fund the litigation personally, privately, for example, then an uplift or part of the uplift shouldn't be recovered. And it's only if the claimant can demonstrate that he or she had no other means of funding the litigation that this element of recoverability of the uplift comes into play. So quite quite a lot of difficulties, it seemed to me. And finally, I think this shows some of the difficulties. This passage, the comment that the judge made that he did not know the precise terms of the agreement and what is the definition of success. And he said, if his award does not bring about the operation of the uplift, he will revisit this element of the award. Now that, I accept, maybe it's in rare cases that one has a CFA that defines success as only success if the claimant obtains more than X. But if you have that, then you do have a circularity problem, and it's potentially quite a serious circularity problem, because you can envisage a situation in which the success definition is met, and therefore the liability to pay the uplift is triggered, if the award includes a contribution to the uplift, but on the other hand, success is not triggered if the award does not include a contribution to the uplift. And that creates a real, I think, difficult circularity problem. And finally, we have what we also saw in Bullock, the idea that because of what the judges acknowledge is the potential unfairness to the estate, to the defendants, a discount is in effect applied, both in Bullock and in Re-H. And so what the judge does is, in both cases, the award that is made is a percentage of the uplift. In the case of Re-H, it was a 25%, effectively £16,000, which he said, the judge said, approximates to a 25% uplift. Now, why, one can ask, and what if it subsequently transpires when privilege correspondence is revealed that, for example, there was some conduct by the claimant which the court might ordinarily want to show its disapproval of, and normally it does so, as we all know, through a costs award. For example, an unreasonable refusal to mediate. What can you do about it then when the decision to award part of the uplift has already been made when the court has decided the merits? Very difficult, I think, very difficult issues, which make these two decisions, in my view, rather problematic. And as I've said, and let me repeat, I don't say that in a sort of purely critical way. I completely understand and see where the judicial sympathy came from, and see the real thorny issue which the judges are having to grapple with here, the tension between doing justice to the claimant and not unduly prejudicing the deceased, the deceased estate, the defendants, the estate. Let me finally touch on some practical implications which I think are likely to follow from these decisions. Of course, at the moment, we have two directly conflicting High Court authorities. And so it seems to me that as a matter of simply sort of analysing precedent, it is open to someone who argues this point again in the High Court to re-argue it and to decide which one should be, try to persuade the judge as to which one should be followed. But I think some of the practical difficulties for those of us who are dealing with 1975 Acts and CFAs in 1975 Acts are these. First of all, I wouldn't be surprised if particularly Re-H encouraged use of CFAs, which first of all provided that any recovery is a success, and it may well be that the vast majority of CFAs already do so, but also whether the decisions are likely to encourage CFAs which provide for a 100% uplift, particularly, of course, if one is concerned that the judge might reduce the percentage, award only a percentage of that percentage uplift rather than the full uplift, as was done in both Re-H and in Bullock. As I've already touched on this point, but it's not clear whether the claimant will be awarded the entirety of their uplift, and if not, what proportion of it, and why. And I think that makes it very difficult to negotiate. And I think in particular, it will make it difficult to pitch Part 36 offers at the right level, because if you are a defendant and you want to try to settle a 1975 Act claim, which you know the claimant is pursuing on the basis of a CFA, you might think, as a result of Re-H, that you are going to include an element of the claimant's uplift. But of course, the million-dollar question will be, well, what element, what percentage? Or you might know what the uplift is, because the claimant will have told you so, but then you're going to have to make a very difficult judgment call as to what part of that uplift you think the claimant is likely to recover at trial, and therefore what part you think you're going to include in your Part 36 offer. Final slide. I think it is likely, I suspect, to make it more difficult in some cases for the estate to buy off weak claims, weak 1975 Act claims early on. And that may well result in the estate deciding to take its chances at trial. It might have the effect of making the estate entrench its position and say, well, no, if I'm going to have to pay you so much because I have to include an uplift in order to buy your claim off early, I might as well take my chances at trial. What can we do practically? Well, I think actually in practical terms for the litigators who deal with these sorts of claims, well, if you're a claimant, I'm sure you will have already thought of and probably done this, you're going to be notifying the other side, I would have thought, fairly swiftly, that you are funding, your client is funding the claim, is pursuing the claim on a CFA, and you're going to tell the other side what the terms of the uplift are, obviously on the basis that you're going to, I would have thought, be saying if the claim succeeds, we're now going to be including that we're going to be asking the judge to award as part of our client's claim and the award made to our client a contribution towards the uplift. For both sides, I think both claimants and defendants, the practical point that seems to me is the immediate one, is review and potentially revise your existing settlement offers, particularly if, the obvious example is if you are a defendant, you have made an offer, maybe a Part 36 offer, which did not include an element of uplift. Do you now think actually we had better revise that and make a more generous one that includes an element of uplift? Or of course, you might take the view that actually, because the state of the authorities is not clear, yours is the case to use to argue this point again. So that's it from me. Let me have a look at the Q&As to see if there are some questions. We've got a few questions, so I will read them out and then provide you my attempt at an answer. The first question is, do I feel that H and NH would have been decided differently had the elderly mother beneficiary under the will been represented at the final hearing, she having been unrepresented and barred from participating in the hearing through defaults at earlier stage of the action? Very good question, if I may say so. It is absolutely right to say, and the judge records in Re H, that the defendant mother, who was the sole beneficiary of the estate, had repeatedly breached various orders and therefore was effectively debarred from taking any part in the proceedings, and it was not represented, did not have any legal representation. So could the result have been different if she had instructed solicitors and counsel to argue the point? Possibly. Possibly is all I can say. I think I must say, personally, I find the reasoning in Clarke quite persuasive. But as I have said, and I acknowledge again, I can certainly see that judges are really grappling with this problem because it does seem intrinsically not right to know that you are making an award that is as bespoke or as tailored as you can for that particular claimant in question. You're trying to make reasonable financial provision for him or her, and then you're told, but actually that's going to be significantly undermined because she's going to have to pay her uplifts and potentially or DBA liabilities. So possibly, I think the result might have been different if the mother had been represented. Next question is, does this change Liamman in that case the position wasn't argued and appears from the cost judgment to have been effectively a concession? There appears to be a wider scope for arguing that costs liability beyond CFA specific liability is part of the claimant's needs under Section 3. Potentially, that's again a very good question. I mean, Liamman didn't itself involve the CFA, so it wasn't directly on the question of uplift. But I think it's right to say that the approach taken in Liamman was effectively to say to the judge at trial, ignore costs. We're not going to tell you anything about costs because we're going to have to argue about costs later. Only once you've decided the case on the merits are we then going to tell you what offers there may have been and what costs order we therefore invite you to make. That in itself is quite a tricky approach. Obviously, I've had cases since Liamman that went to trial, and we said to the judge the same thing. It's problematic, but I'm not sure I'm afraid what the answer to that is. And indeed, Mr. Justice Briggs in Liamman clearly says in his cost judgment in Liamman, we need, I'm paraphrasing obviously, we need Parliament to look at this. Should we be thinking, he suggests in Milliman, of a no costs regime that applies to divorce? I'm simplifying that enormously. So is there going to be a move in that direction? Query. And I think on that, it's quite interesting that we probably have now a lot more CFAs being used in 1975 Act claims than was the case when Jackson was looking at CFAs in 2009. And so now it is really an area that one should be looking at, I think, and potentially thinking about reform. But of course, potentially that is at Parliament level, I would have thought. And as we all know, Parliament seems to be rather busy with other things, rather slightly more pressing things at the moment. Next question, I've got a few more. Should defendants who have made Part 36 offers, oh, another one's just appeared, where is it? Should defendants who have made Part 36 offers be following up to clarify whether the offer is to include the uplift or not? Good idea. Why not? I think that's part of the problem is this is going to, I think, create debate. Is it including the uplift or not? And so I see the sense in following it up and saying, just to clarify, that does include costs and uplift. When I refer to the estate as a notional defendant, that is presumably where the executors and administrators have elected not to take a neutral stance. No, sorry, I use there the estate as the general other party to the claim. It varies in these cases, but normally it is the executors have been joined but take a neutral stance, and it is, of course, the beneficiaries of the estate who decide to defend the claim on the merits. I've used the term loosely as to whether it is, and forgive me, perhaps what the question is heading towards is if you have professional executors who have been joined to the claim as defendants but have rightly taken a neutral stance, and they have said it's really a dispute between the claimant on the one hand and the beneficiaries who are themselves joined on the other, and we the executors are going to stay neutral. I don't think it is for the executors to get involved. I don't think these cases change that position as regards those neutral executors or administrators who are caught in the middle. It's really for the beneficiaries as the defendants to decide whether to review their offers. I'm running a professional negligence claim under a CFA relating to a negligently drafted will. My client has a loss, but will lose some of it through uplift. What's the difference? Good question. It's really a policy difference, and whether it's a justifiable difference or not, I think depends very much on points of view. You will have seen one of the interesting, I thought, points to emerge from Jackson's recommendations was that there seemed to be a real concern that in the context of personal injury, the award made to the claimant to compensate the claimant for that injury would be eroded by legal costs. Why doesn't that apply elsewhere? I think that's a very good question, and arguably it should. Do I think that Bullock and Re-H also potentially applies to the recovery of any uplifts that firms may charge under deferred fee agreements and not just CFAs? Potentially. I think it depends. What one really needs to look at is the terms that govern that liability. And you will have seen in particular in Bullock how the judge analysed the claimant's liability to pay her lawyers and when that liability is triggered, and can you say, as the judge analyzes in Bullock, that it is a debt of the claimant, or it will become a debt of the claimant, and that it is a debt that arose after death. But I can see that it is not, arguably not limited simply to CFA uplifts, and could have wider implications and could apply to other liabilities. Yes, I think so. Do the recent decisions of Bullock and Re-H enable the defendants to more easily obtain disclosure of the CFA agreement from the claimant? I suspect so. I suspect the reality is that the claimants are probably going to shout about the terms of their CFA to anyone. It's one of the perhaps unusual features of these two cases, is that the court is told quite a lot about CFAs before one gets anywhere near a decision on the merits and then a question of costs. And ordinarily, some of you who may have been dealing with CFAs many years ago before Jackson came into force, you will recall, certainly I was brought up on the basis that you didn't tell the other side what percentage uplift in particular your CFA had, because that, you were worried, would reveal to the other side the merits of your claim. It seems to me this does change the dynamic somewhat, because I suspect it will be in the interest of many claimants to say unilaterally, defendants, I am acting on a CFA, my solicitors are acting and counsel are acting on CFA, and this is the uplift, and this is the percentage. And so please take this into account when you are deciding what offer you want to make to get rid of my claim. So yes, I suspect it will be, we will see more disclosure, more ready disclosure of CFAs by the claimant. If the defendant was unaware of the existence of the CFA, even at trial, and this was not referred to in the claimant's evidence, presumably the claimant's claim for the uplift to be taken into account will fail. Well, I think that's an excellent question, if I may say so, and I think it is very much a point. I think it's the reason why I say I suspect we will now see claimants unilaterally announcing that they have retained their lawyers on CFAs and what the terms of those CFAs are. But I can certainly see the force in an argument at trial that says, in effect, Judge, you can't take this into account because you can't award against the estate a contribution to the uplift because the estate didn't really know about it. My suspicion is that in reality what is likely to happen is that there may well be disclosure, even last-minute disclosure by the claimant of the existence of the CFA. At trial, the court may well take into account the liability to pay the uplift, and if the court decides to follow Re-H and Bullock, award the claimant something towards that uplift. But then there's going to be, I think, an interesting costs argument, particularly if there were settlement offers, as to whether an offer was beaten or not, and whether the court, depending on the timing of the offer and the timing of the disclosure of the CFA, should consider and treat the offer as beaten when, for example, the offer is not strictly beaten at trial because the judge has awarded a contribution to the uplift, but would have been beaten but for that contribution. So you can see there's some difficult arguments about the justice of awarding costs against a defendant in those circumstances. Would you have considered appealing the decision in either Bullock or H if acting for the defendant? Oh, difficult question, putting me on the spot. Well, I think I have to say Bullock, as I've already mentioned, I think there would have been an appeal point, except that of course it was overtaken by Re-H, which was that Clarke was binding authority in Bullock. Re-H, possibly. I think the difficulty, however, one has to bear in mind is that the amounts at stake and the amounts that would actually, the financial consequences of an appeal being allowed are relatively minimal. And I don't say this in a very grand way, but the figures we're talking about, when one measures those against the likely costs of an appeal, one can see that it's a difficult cost-benefit analysis for the defendant. Say, is it worthwhile appealing the point when the amount at stake in neither case was enormous, or perhaps even large enough to justify the costs of an appeal. Final question, I think, is the claimant and first defendant in Re H each had the release of some funds from the estate earlier in the action for funding joint medical expert. This could be relevant to the other means of funding point, but what was not raised or addressed in the final decision. That's interesting. That's a helpful contribution, for which many thanks. I did not know that. But again, I think and I hope reinforces the concerns that I certainly have about the question of taking into account the claimant's ability to have other the availability, sorry, of other funding options, and is that something that is really relevant, and if so, how? Which I think is quite a difficult point to emerge from Re H. Those are all the questions which I hope I have been able to at least give an attempt to an answer. Oh no, I spoke too soon. There is one more. Is a court likely to consider proportionality on assessing the extent of the uplift if this is in fact simply a contractual liability of the claimant that he or she will have to pay? Well, that's again a very good question, if I may say so. And I think the difficulty I have with the approach taken is that only a percentage of the uplift was awarded. And it's quite difficult, it seems to me, to understand precisely why the court decided to adopt to apply effectively a discount to the amount of uplift that it was allowing as part of the award that was being made to the claimant. It seems to me that both Bullock and Re H, the reasoning in those decisions is quite is not as clear as it might be, and I think makes it difficult to anticipate how a court is likely to approach that same exercise in a different case. And I think it is open to argument as to whether it is the right approach at all, where, as the question says, it is in fact simply a contractual liability of the claimant, so should a discount be applied at all. But one can see, again, I do empathise with the judges who are clearly trying to square the difficult circle of preventing injustice both to the claimant and to the defendant, and they very much say so. They're trying to grapple with that difficult exercise of squaring that circle. I will end here, and it remains for me to say thank you very much indeed for joining me. You have my email address on the slide, so please do get in touch if there are any other questions that I haven't answered, or if you want to have a discussion about any of this. I think it's an interesting and evolving area, and I suspect we will see quite a lot of developments in the near future in this. There are details, as I said at the beginning, this webinar is going to, the recording of it is going to appear on the Five Stone Buildings website, 5sblaw.com, where you can also find details of forthcoming webinars in this series, and indeed recordings of previous webinars to which you can find a link. I will end the webinar and presentation here. Thank you once again for joining, and goodbye.